Okay, good afternoon, everyone. Thank you so much for joining us today. On behalf of IP Osgood and Osgood Hall Law School, thank you for joining in the IP Osgood Speaker Series for this exciting event. Now, I'm Professor Giuseppina D'Agostino, for those of you who don't know, the founder and director of IP Osgood, Osgood's flagship IP and tech program. And if you haven't done so already, if it's not on your homepage, iposgood.ca is the go-to place of all that is fun and exciting in IP here in Canada and around the world. So do check it out, and do see that you'll find a recording of today's session along with a blog that'll be written by Philip Poles, who joins us back. He's an Osgood grad, so he'll be blogging on this, overseen by Benjamin Farrow, who's our contents editor at IP Osgood. So this event couldn't be possible without, of course, generous support and a lot of organizational know-how. And I'm very grateful to our industry sponsors and our 5 founding law firms. And I'd like to acknowledge the Canadian Copyright Collective, the Audiovisual Licensing Agency, and the 5 law firms. So Gowlings, Castles, McCarthy's, Norton Rose, and Oslers. And of course, our logistical team. Michelle Lee, who sits there, she joins us. She's the newest addition to the IP Osgood team. She's the IP Osgood coordinator. And sitting right beside her is a very capable Mary Barbieri. And both of their enthusiasm has really been infectious and has really made this operation work well. So I'm very grateful to them. I'd like to give them a round of applause. Now, as many of you know, IP Osgood aims to inject many new voices to the IP debate and really intensify the learning opportunities for our students. And today's event is no exception. In fact, we are quite privileged today to hear from one of the luminaries in the IP community. And here I should mention that his reputation as a luminary isn't just one that is in the present. It's one that was very much in the past when he was working very, very hard. And I have here a little story for you to recount. I'm not sure if you've heard of the name David Tobin, but he is the former head of the Canadian Intellectual Property Office. So when he took the helm and became the Commissioner of Patents, this was back in 1999, what he decided to do was, the first 2 years, I'm going to go out and talk to all the who's who of the IP community and really get a sense of what they think of CIPO and how we should make things better. Well, guess what he decided to do? Knock on Roger Hughes's door. So he was the very first person out of anyone he could have chosen across the country, the very first person he wanted to speak to and really get his insight in, because he trusted him and he really respected him. So he wasn't alone. This was matched by his adversaries, because when he was in litigation as a practitioner, he had many on the opposing side that had his respect as well. Of course, he practiced law from 1969 as an associate and then partner as Sim Hughes, Ashton and McKay, and Sim and McBurney, and was appointed to the federal court in 2005. Now, his cases both as an advocate and now presiding as a judge on the bench are really what we study here in our IP classes. I can't think of one class where one of his cases doesn't come up in some way and you don't see his name somewhere in the proceedings or on a judgment. And here I should mention that he's a dear friend of the law school and is an active member of the IP Osgood Advisory Board. In fact, he's been on double duty this week, because we had an advisory board meeting on Tuesday. After we heard from Justice Rothstein, we were all basically sitting around the table, and Justice Hughes was there once again relentlessly supporting Osgood. Now, I should mention, in a Festschrift book called The Common Law of IP, how many of you have heard of this book? No? Well, I have it right here. So here it is, and you have to see this book. So it's called The Common Law of Intellectual Property, Essays in Honor of Professor David Vaver. So Professor David Vaver, who I should also mention is a dear friend of Justice Hughes, we put together this book. I was a co-editor in this book. And we decided to do, this was along with Catherine Ng and Lionel Bentley, is go around the world and see the who's who of the IP community, and this on a much larger scale, that have some connection with Professor Weber, and we looked to Justice Hughes. So Justice Hughes was good enough with everything on his plate to contribute this incredible chapter, which I really need to quote from, and it is chapter 6. So when you get this book, you look to chapter 6, and chapter 6, the title of the chapter, Emergent Diversity in the Common Law Relating to Intellectual Property, How Domestic Court Practice Informs Local Evolution of Law. So that's this chapter. And then he has this, the first section is called In the Beginning. Now this is how Justice Hughes begins. Asking how litigation begins is rather like asking how persons fall in love. The answer is that there are all sorts of ways, good, bad, and indifferent. So with that very provocative beginning, I would love to pass the floor to the Honorable Mr. Justice Roger Hughes himself, who will be speaking on advocacy skills and IP observations from the bench.
Thank you. Well, I don't know if it's going to be as good as all that. Let me take this away. I'll talk to you for a while, then I hope we can have some discussion and interactive and what have you. Is this going to do something interfering?
No, I think you're going to...
Okay. Are we now electronically perfect? Okay. You've spent several weeks, I think, is it weeks or, yeah, studying the cases, studying the law, studying the authorities and what have you. And I wanted to give you today an inside of what the judges do. I mean, you're reading the product. You're dealing with the decisions, the reasons, and what have you. But that's only a very small part of what it is that we do and how we do it. So I wanted to give you an inside of what we do and how we do it, and then invite you to discuss what you think the outside result is or has been. Okay? So that's where I'm going. So we have a number, if you like, of audiences for our final product. The first one is the consumers, who are the parties themselves, the lawyers, the general public, and God forbid, the Court of Appeal or Supreme Court of Canada. Now, from the parties' point of view, they really don't care about the reasons, the 120-page or whatever it is of reasons that you write or your legal thinking. What they want is a fair, for that read in their favor, quick, clear, and efficient process and judgment. I've heard a number of business people say, I don't care so much about the result of what you do as much as I care about having you do it now so that I can get along with the planning of my business and the sorting out of my affairs so I can go to the next step, win, lose, or draw. From the lawyer's point of view, other than get paid their lovely retainer, is they want the court to hear them, to hear their arguments, and to be respected in making those arguments. I'm going to return to good lawyering in a while. What the public wants is clarity. Now, we've all been to cocktail parties, sitting in a pub, talking to your relatives over Sunday afternoon tea or whatever. Say, well, I want to know, if I park here for 15 minutes and one more minute, do I get a ticket or not? I want to know. They want clarity. They want bright lines. They want what they call bold letter or black letter law. They want clarity. And for the Court of Appeal, if they ever get the matter, they want a trial judge to get the facts right, to articulate the issues, and to be wrong, so that they can come in and clean up the mess. As one trial judge in the US put it recently, a trial is where all the battle happens, when all the yelling and the smoke of war and so on is there, and the judge has to make a determination and cut through the swath. The Court of Appeal comes the next morning, walking through the battle when the dust has all subsided, and shoots the wounded. That's their job. So that's your characters. So what do I do as a trial judge? The stuff that you don't see. You see the tip of the iceberg. What's underneath the iceberg? I get seized, as they say, with a case a few months before it's to be heard. Now, there are several cases that take an hour, half a day at most, no time at all. And I'm not talking about those. I'm talking about the cases that you read in your textbooks and reports and what have you. My first job is to organize it. The lawyers, in effect, are looking for the court and the judge. They want to cover their butt with our pants, okay? They don't want to often make a hard decision that they know has to be made in terms of how do I get on, what things do I concede, how do I proceed. They want the court to tell them. And you can't imagine how many meetings like this I have with lawyers, and they constantly say, we want you to tell us what to do. We want you to whip us, beat us, make us write bad checks, but we want you to tell us what to do so we can go back to our client, even though we desperately wanted to tell them from the beginning to do so and so, to say, well, goodness, the judge is making us do so and so. So our first job is to organize the case. If we can, reduce the issues. For goodness sakes, you don't need to prove this document. Just admit it and get on. That's not critical. Settle the facts if you can. And find out what's important and not important. You can't imagine how many lawyers can't just sort out the important from the trivial. And we have to do that. So that's the first thing that we do, is in one or probably several pre-trial conferences with the lawyers, sometimes with their clients, and organize the case. Now, somebody's going to ask, what about mediation? At any time, the parties can go off to whoever, Weber, for goodness sake, and see if they can settle the case. That's their business. My business is to get the matter in trial. If you look at it this way, we have only one thing to sell. That's time. Our inventory is time. So we want to reduce the time in court so that we can get a case from A to B, B being the finish line, done efficiently. Everybody's entitled to their day in court, but they're not entitled to the next guy's day in court. And when we've got an overwhelming number of cases, we have to move them through the system efficiently. So a trial. Again, for the first short while at a trial, it's organizing the matters. How are we going to mark the exhibits? What's admitted? Can we just put in a whole bunch of materials without having a lot of formal ways of proving it in evidence? Then we hear the witnesses. And there's various ways of hearing witnesses, just getting an affidavit, having them in the witness stand, just like Perry Mason that you see there. We have a new technique called hot tubbing. Have you heard about that anywhere? It's not what you think it is, okay? Although it did come from Australia. What we do is usually with in fact, only really with expert witnesses, is one expert will hold one opinion and another expert will hold another opinion. Each of them will give their evidence. Then you put them both in the witness box. You say, well, I've heard your evidence, I heard your evidence. You're apart on this, this, and this. Am I correct? Well, yeah, okay. Now, about point this. As I heard you say that, yes, and I heard you say that. What is the real difference between the two of you? And they talk to each other. And you'd be amazed how much sort of comes together in this hot tubbing. So that's the new trendy way of dealing with things. When you're done with the evidence, You then hear argument from the lawyers. And usually you give them a day or two to compose themselves and ask that they file you written memorandums, and they will file you something with 1,000 pages in it if you let them, but you don't let them file more than 30. Okay? Large font, nothing squeezed in, okay? If you can't organize your thoughts down to 30, you're not a real lawyer. We hear the argument. Now, post-trial, and I'm going to come to this a little later, the lawyers are done. They go out and have dinners and parties and vacations in the Bahamas. That's when our work begins. And we have to take all of this evidence and somehow, with the arguments and the issues, reduce it to reasons for judgment and a judgment. Okay? And that's sort of something you do in the quiet of your room and organizing this and sleeping or not sleeping at night and all of that. Then you write your reasons. You get them edited by somebody, make sure you haven't misspelled and what have you, and out they go. Somebody's going to appeal, almost inevitably in a big IP case. The Court of Appeal really has to look at the matter, respect, by and large, although some don't, the factual findings of the judge, and then resolve the legal uncertainties or correct what they perceive to be the errors. Okay, so that's the process. If it goes further to Marshall Rothstein, for instance, the Supreme Court of Canada, they're interested in correcting errors and so on, but they're mostly interested in setting policy decisions, public policy decisions about how should the law go, how should all these massive cases be resolved into something else. And you've heard from him earlier this week, so I'm not going to get at that. So let's go back again to the process. And there's the first thing that you put in mind when you're a lawyer and what a judge is. And this is the first thing that they teach. There's a school colloquially called Dumb Judges School. When you've been out for about 2 months and know where the washroom is and the coffee room is, they send you to Dumb Judges School. And the first thing they tell you is, what's the ask? Have you heard that? What's the ask? You know, somebody wants you to donate to their charity. So you say, what's the ask? Come on, $100. Okay. What are you asking me to do? That's the first question that you have in your mind and that you ask the lawyers and their parties. You've got this wonderful case. Weber has a great exposition on how it should be decided. But what do you want me to do? What decision do you want me to write? If I take out this pen, what's not my reasons, never mind that. What order do you want me to make? Well, I want you to say that the case should be on the front page of the Globe and Mail. I want to be really famous. I want to get lots of money from my client, and I want to be adulated. That's what you, Mr. Lawyer, wants. What does your client want? Well, they want the bad person to stop. And they want lots of money. How much money? What do you want? Well, I want him to get off my case and I want to carry on with my business. What's the ask? Think about that. Whenever you get a situation you have, whenever you read a set of reasons, where is the judge heading to? What's the ask? What's the final resolution? Okay. And in doing that, then I'm starting out by getting the facts right. Where do I start? What facts are you agreed on? And you sit the lawyers down and say, okay, that's not in dispute, that's trivial. We can agree that the 27th of November or 29th of November is a Thursday. Can't we? Well, I don't know, why don't Julian calendar? Shut up, sit down, get on with it. Okay. What facts can you agree to? What facts do you admit? What facts are presumed to be true? You know, we've got things like the Evidence Act and other things, the judicial notice. What facts are presumed to be true? So what facts then are contested? Okay. First thing I have to ask myself is, who has the burden of proving that fact? Is it this side or this side? Because at the end of the day, if it's not proved, or if I'm not satisfied that it's been proved properly or enough, they lose on the burden. So who has the burden? Are the facts that you allege supported by evidence? And if so, what is that evidence? Is it documents? Is it a witness? Is it both? What's the evidence? If it's a witness, is that witness credible? Now, you've all seen LA Law and so on, where the witness breaks down in the stand and says, no, I never did that, and it's a pack of lies. They don't ever do that. That's la la land. So credibility, you've got to look at a person, see if they wear brown shoes with a dark suit. You've got to look at them hard for that. Is it plausible, what you're telling me? Here's a case, immigration case that I did. A fellow said, well, I flew from Africa to Canada and landed and claimed to be an immigrant refugee because they were beating me up. Question, well, why didn't you report it to the police in your home country? I didn't have the bus fare, but you had enough money for the airplane. There's things that aren't plausible, and you've got to go through plausibility. What is the burden? Is it a civil burden? That is balanced probabilities, more likely this than that? Or is it a higher burden? That's usually in a criminal case, but in some other matters, you'd have a higher burden of proof, beyond a reasonable doubt. Or as the Americans call it, clear and convincing evidence. So that's what I've got to do. That's part of my job at the front end. The next, and I think this is the most important part, what are the issues? Now, you've seen reasons for judgment, and usually you set it out near the beginning. The issues are 1, 2, and 3, or 4, 5, 6. It's not just, is this scumbag infringing my patent or not? It's, is the patent valid? Okay, and in that respect, 1, is it obvious? 2, is it sufficient? 3, and so on. Okay, so you have to break down the issues and make sure that you focus on and address the issues. It's part of the organization, but it's very difficult for some lawyers and for some judges to know what the issues are. They sort of write in a cloud, a judicial cloud, J cloud. They just sort of write and think around without really knowing, is this relevant to this issue or what? That's the most important. What are the issues in order to get to the ask? Then you look at the relevant law. Some law is very plain, very easy, not really disputed since forever. Some law is maybe this way, some way that way. Some law is very edgy. And you listen to the argument of counsel. Some counsel just can't argue at all. Some counsel are very, very good. Most approach the very good, certainly in IP cases. But you have to listen to what counsel argue. But you also have things in the back of your mind that you know. And by and large, as a judge, I do, and many of my colleagues do, during the argument, say to counsel, yes, I hear you, but what about the case of so-and-so? What about that recent case of Teva in the Supreme Court of Canada? How does that bear on this? You try to dialogue with counsel to get that out. Sometimes, not often, this has happened recently in a case, one of my colleagues, a case comes out, in this case in the Supreme Court of Canada, that affects the thing that you're still thinking about. What you'll do is you'll call counsel back in and say, here's the decision, it's an important decision. Now, I'm not talking about just one more decision along the road of well-known law, but really breakthrough cases, and you ask them for more submissions on that. If you ask them for that, you get 3,000 pages of I don't know what. So you ask them for 5 pages and half an hour of speaking. Okay, so you talk about that. And then you're trying to apply the law. So how do you do that? Statutory interpretation, you get all kinds of rules. If you read, anybody read Dreiger or Sullivan on statutory interpretation? You can find something that'll support almost any interpretation you want to arrive at, can't you? Okay. There is generally known law. Right now, the law of obviousness is really well known. if you have to go off the edge, generally you want to do the least harm you can. Go the least increment that you have to do. Because you know, and this has happened to me, if you make a decision, 2 years later, it's going to come back and bite you. You know, some guy's going to pull it out of his briefcase and say, well, you said in the case of so-and-so, you know. Yeah, but that was different. Why? I don't know. Just different. So you have to be very careful when you're going outside the bounds of what's known to try and do the least harm. So we've gone through that, and now to the what's the ask, okay? And I'm going to put it a little differently. Remedies, okay? Have you taken a course on, or is there a course on remedies here? Okay. Think of it in two ways, okay? First is, what must I do? If you look at the Patent Act, I must, if I find a patent to be valid and infringed, consider damages. What may I do? I may, instead of damages, award profits. I may give an injunction. I may order delivery up. If it's a copyright case, I may award both damages and profits. In certain cases, I may award anything between a 3-fold and a 10-fold amount of damages. I may, in statutory damages, do things. You have to distinguish between what I must do and what I may do. And counsel, of course, if they think they're going to win, try to push the may pretty hard, 10 times for sure. Why? Because I don't like the other guys. You know, kind of rude. There is an area of, let me call it, creative remedies. There's an area in the may area, not in the must area, but in the may area, where some judges in some cases get creative. They say, yes, you win. Yes, the patent is valid. Yes, it's infringed. I'm going to award you $1 damages, and I'm not going to do anything more. Have you seen that in some of the Apple Samsung things? Judge Posner, have you heard about Judge Posner in the US? He's one of the best creative guys. He's the guy who sentenced Conrad Black, if you remember that. Same guy. Where you're saying, look, this is all theoretically very nice, and this person's got a patent that covers some small feature of these incredibly complex devices, but should I shut down a whole industry because they've got this little corner of something there, even though they're correct? So you say, you know, you try to take a step back and say, what am I doing here that will do the least harm and still reward the party who won appropriately, not enormously, and so forth. The last thing I have to address, and nobody seems to think about it except the lawyers, is costs. You've heard of the word of costs? Okay. Costs are supposed to be, in the English/Canadian system, partial compensation for the expenses that you've incurred as a winning party in winning the lawsuit. Many of your out-of-pockets, that is, disbursements, are covered, and some of the enormous bill that you've paid to your lawyer is covered. But not all of it. Because a losing party shouldn't have to pay $1 damages and $1.2 million in costs. So you try to ameliorate costs as well, which has an effect, you hope, in keeping lawyers' fees down below the top level Mercedes-Benz dealer level on that. So those are the things I have to think about when I'm doing it. I'm going to shift to what is a typical patent case. How do I deal with a typical patent case? Have you all taken patents? Have you all seen a patent? A patent is not the leather of your shoes. A patent is, you know, a document with a seal on it. Okay. How do I approach a patent case? Having done all this organization and skills and facts and all that. The first thing I have to do is put myself in the position of a person skilled in the art, okay? I move away from being a judge to putting myself in this notional text, the reasonable man in torts, the person skilled in the art. This is very common in almost every jurisdiction, that you have to look at the material as this fictional person. Then I have to ask myself, what's the relevant time that I look at the world in the eyes of this person? For obviousness, there's the date of filing. For understanding the patent, there's the date of publication. There may be other dates as well, depending on how old the patent is and that sort of thing. Then I have to ask myself, as of this particular date, what is the body of knowledge that a person could reasonably have been expected to know? Now, we're not talking about anticipation, where Justice Jacobs says it's the great scientific text misfiled in the children's section of the Alice Springs Library, but rather, what does a reasonable person working in this technical area have been expected to know or expected to have looked for as of the relevant date? You get on your computer and you punch in the keywords. What are you going to look for as of that date? Then you read the patent, the specification, and then the claims. As such a person skilled in the art, with this body of knowledge in your head. So far, okay? Everybody still with me? Good. And then you do this ingenious little trick called construing the claim. And as the Court of Appeal will say, as of last Friday, construing the inventive concept. That's a bit of a battle between me and the Court of Appeal. But you have to engage in some constructions. It's remarkable how a claim that might just say aspirin suddenly becomes so complex as aspirin, but only taken twice a day, provided you don't have a headache, and all kinds of other stuff. This is where the lawyers start getting at you. But you have to construe the claim. And having construed the claim, you compare the alleged infringing article through the eyes of a person skilled in the art with the body of knowledge. Have I done enough exercises for you? Okay, you understand that. And then you also compare the claim as construed to the alleged prior art that you say either anticipates or makes obvious the claim. Or if the issue is, as the Supreme Court of Canada told us a week or so ago, whether it's sufficient or not, you're looking at the patent as a person skilled in the art at the relevant date and say, do I have enough knowledge here to allow me to know what Viagra is, for instance. So those are the exercises that you go through. You're aided by experts who will sort of say one thing on one side, one thing on another, and if you hot tub them, you kind of get them down to a little thing. You might decide that one expert's preferred to another, either because better qualifications or they simply are more credible on the bench. You rarely decide it on the basis of the necktie they wore or some other nervous tic or whatever they might have. You try to listen to what they're saying. And that's your task in a patent case. I'm going to move to a trademark case now. Let's start with a passing off type case. All of you taken trademarks? All of you know something about it? Okay. The first thing you have to ask yourself is, what is the mark? I use that word very generously. It could be a sound, it could be a color. It was supposed to be a Scrabble tile. Did you see that one from the UK court yesterday, the Scrabble tile? What is it that you say that you have that possesses goodwill? What evidence do you have that it's distinctive? And distinctive in what, either geographical area or trade area? And how far does that extend? If it's a registered trademark, that of course is sort of short circuits that, and you say, what is the mark as registered? And some people take their eye off that ball. And for what wares and for what services? Again, they take their eye off that ball and look at it as used, which you don't. Then you look at what the offender, alleged offender, has done. All right, what have you done? And you compare it with the registration. You can't imagine how often people don't do that. They compare it with one package to another, for instance. Not fair. Or you compare it with the thing, if it's not registered, that they say is the thing in which they have goodwill. And then you put yourself in the position of another fictional character called the average consumer somewhat in a hurry, okay? You know, the running idiot, as they say. And you put yourself in that person's shoes and say, would I be confused with one or the other? Either as to one product being the other, or one product being sourced from the same place as the other, the debate's still out on that one, or one product licensed by the other. That's a fairly new one. And if that's so, if that's the case, has there been any damage? We'll look at that. So you can see again, we're trying to break our case down into components. We're trying to put ourselves as a fictional person. Torts, reasonable man. Patents, person of ordinary skill in the art. Here, the average consumer somewhat in a hurry. Funny people, eh? Every day you change to different. Copyright case. Again, you have to look at what is it that you say is the work in question that you say, Mr. Plaintiff, you own. Sometimes it's very hard. A lot of them, newer cases say, well, it's a concept, it's a way of doing something, forgetting that copyright has to be something fixed. And I use that word even in a computer sense, of fixed in form. And you get a lot of cases that are really trade secret cases or contract cases where they're trying to jimmy the facts into a copyright case. Who's the author? Well, it's all of us here. We just kind of sat around. Well, who are they? Canadian citizens? No, we're all from Antarctica. And who is the owner? You won't imagine how many cases in copyright that nobody's quite sure who the owner is, especially if you get things like songs and films and things like that, because they buy them, sell them so rapidly, and in comes some tax hotshot who says if you set up a Western Hemisphere corporation and own everything in the Dutch Antilles, then it's going to do this, but then you've got to sell it within a year and go over to the Channel Islands. Nobody quite knows who the owner is. And you got to put, well, it's kind of presumed. No, it's not presumed. You got to prove it. You're the plaintiff. Tell me you're the owner. Then you take a look at what the alleged infringer has done. And here you get into this other thing of substance. Well, they haven't taken it exactly. They kind of took the substance of what I'm doing. Yeah, what's the substance you say is doing? And then you look at that wonderful thing, the new Copyright Act, and Marshall Rothstein was talking about all these new exemptions. Now, these exemptions are one-legged kangaroos on a Sunday, provided they're not singing at a church service. Isn't that one of them? There's umpteen pages of exemptions, and you look at that. Now, there's no, the person like the other persons we're talking about, except beholder. In the eye of the beholder, in the ear of the beholder, or the listener, who is it? Okay, so you've got to sort of put yourself in the sort of beholder thing and say, well, what is the work, and have you taken the substance of the work over here? So those are the sort of characters that we have to assume when we're being a judge in certain IP cases. Now, I'm going to give you tips. You're all going to be or have been, or maybe one day will be, a lawyer. So I'm going to give you a few tips as to good lawyering, okay? Keep it as simple as possible, but not any simpler, but keep it as simple as possible. everybody falls in love with their pet theories or their pet piece of evidence. Is it really necessary to arrive at what the ask is, the result you want? Keep it simple. Or as they say in football, the KISS play, keep it simple, stupid. Okay? Go only with your best issues. They call it the rule of 3. If you have more than 3 issues, you've got too many. If you can't win on your first and your best issue, maybe you got a second. If you can't win on your second, maybe your third. But for goodness sake, if you can't win on those, why do you think your 27th issue is going to save your bacon? And that's what you have to do as a lawyer. That's hard. That's why you get paid the big bucks. To reduce the case to really 3 essential major issues. Then with the other side, who you hate and who's played a dirty trick and phoned you in the middle of the night and never did what you said they'd do and they were always late and yep. Try to agree on as much as possible. Facts, issues. Don't fuss the small stuff. You can't imagine how many people come in front of me fussing about small, irrelevant stuff simply because their head isn't organized on the real issue. In court, be polite and pleasant. And adopt what I would call a familiar or folksy style. Some people read it so much that they don't go to this. Then the next point I want to make is, I'm not a computer. The exercise is not to read something so that you've got every point out, that you've covered all the bases. That's the roof tile philosophy. You're there for one purpose, to persuade me that your point of view, that the ask that you want is the right one. You can't persuade me by just sticking your head down and reading. I'm not a computer. I'm not putting everything down and at the end of the day saying what point was covered, what point was... I'm not doing that. I'm saying, what is the right result? And you have to tell me in a dialogue, eyeball to eyeball, why the result that you represent is the one that I should or must make. It takes skill. It's other things like be heard, be polite, be articulate. And there's something called Rule 13. I'm going to come back to Rule 13. Write it down. Rule 13. You should know your case. Inevitably, when you start your argument, I'm going to ask you something. And you say, well, no, I don't know that, or what have you. That giant flushing sound is your case going down the tube. Know your case. Organize your case. Don't say, well, yeah, I'll do a little bit here, and then I'll come back to that later, and I have this over here. This is really hard, the next one. Be truthful with your client. I don't know how many of you had or have a friend, relative, or what have you who has had or has a medical condition. You go in, you get tested, you get looked at, and the doctor, the hardest thing he has to do, or she has to do, is say, you've got this dread disease. Or it's unlikely that you will survive. Or we've got to cut off all your limbs. Or. But that's the doctor's job. It's hard. It's your job too. If you see the case that your client's bringing in, and you know that the client can't win, or must settle for this kind of a remedy, your job as a professional is to be truthful with your client, really hard. Because you want to please your client. You want to get the money. You want to tell your client that they're going to win for sure, except for that awful judge. Damn, we had Hughes again, and we're just down the sewer. But, it's his fault. Be truthful. Be respectful to the court and your opponent. and Rule 13. Rule 13, I'll tell you what it is. Don't piss off the judge. Don't be late. Don't be rude. You know, a lot of don'ts in there. Be heard. For goodness sake, don't annoy the judge. As soon as you get down to, I am really pissed off at Vaver routine, it's hard to get off that track. Okay? So remember that. Now I'm going to shift again, because I've heard a case now. I've heard the evidence. I've seen what the lawyers have as the law. I know myself what the law is. I've put to them any new cases or cases I think they should consider. I think I pretty well made up my mind which witnesses I prefer, which evidence has been established, which evidence has not been established. I know what the ask is. I know what remedies I must give. I know what remedies I may give. And I'm in my office and the door is closed. And I've unplugged the phone and closed the computer and locked the door. And I may sit there for an hour and go home. I may think for days. But it's that quiet moment or long period of time that you have to make up your mind. And that's called judicial independence. That's when you're free from all the pressures of people. I was in the Soviet, as it was then, Soviet Union. And there was a group of lawyers and a group of Soviet lawyers and Soviet judges. And they were being very frank. And one of the judges, I think the vodka was talking, said to one of the lawyers, a woman very articulate, says, "What's the one thing you'd like judges to do if we could change anything?" And she said, "Turn off your phone." She meant from the Politburo. You know? We're free of that. She was found dead 6 months later. We have the quiet of your own room, and you make up your mind. And that's hard. Just like I've seen some things are hard for lawyers. You have to make up your mind. You say, yeah, that patent was obvious, or that patent wasn't sufficient, or a person in a hurry would not be confused between this and that, or the observer, the reader, the listener would not think that that song is the same as this one. And that's when you make up your mind. And that's the hard part, and you write it that way. Now, when I start writing, it's not as if I write and say, oh my goodness, oh, look at that. Look at the way it's turning. I don't do that. I know how it's going to turn out. So I write it from that point of view. I know how it's going to turn out. The Court of Appeal may disagree with me if I'm wrong in the law or if they're just cranky that day. But that's my job, is to make up my mind at the end of the day and then write reasons that will allow you as students and to understand how I went there, Weber and Augustina as academics to show why I was wrong. But nonetheless, I write reasons to explain why I came to that result. So that's how it happens. Okay, let's talk. Who wants a question? Who wants to just vent? Who wants to say that I was really stupid in the last decision I did? Or anything else you want to say?
We have some time for questions, and you need to speak into the mic. Oh, why don't you? Yeah.
Let me just wet down a bit.
Sure. My question's fairly short. I'm just curious in your experience how the balance between written advocacy and oral advocacy sort of influences you in the decisions that you make and how important you think each one is.
Written advocacy is very, very important. When I go in to hear the case, if it's a case done on affidavits, I'll get the written advocacy right away. If it's a case done with witnesses and so on, we usually have a break a day or two or whatever, and then get a written brief. It's the thing I read and is in my mind when I go in the courtroom. When I come out of the courtroom, that's the thing I've got as a resource to sort of compose my thoughts and look back. Oral advocacy is wonderful for the client. It's wonderful for juries. And sometimes it helps, but it helps in a way of me dialoguing with the advocate and saying, okay, now you say that this is the proposition, and I see in your memorandum paragraphs this and that you've explained it. But what I don't understand is so-and-so. Or I'm not quite sure that you're getting me there. Let's talk about it. So standing up and giving this marvelous Cicero-type speech is not as useful as answering the questions and your written material. I think J.J. Robinette, have you ever heard of him? A wonderful leading lawyer in the past, said it this way. He said, 90% of the cases are won in the filing of the written advocacy. The other 90% are lost on the oral advocacy. You're more likely to do yourself harm if you get a little too extravagant in oral than you are to do yourself good. Okay, next question. You know everything now? Yeah, sure.
In technical patent cases, when you're trying to become the person of skill in the art, how much independent research can you do, or do you have to limit yourself to sources provided by the parties?
Yeah. I don't know if have you taken a case of Curate Amgen in the House of Lords? Is that a case that you've talked about? Lord Hoffman. That had to do with erythropoietin, which is a, let me say, a somewhat artificial concentrated blood thing. That's what Lance, no, he never did. That's what some bicyclists are alleged to have put in this. In effect, it's the red blood cell conveyor in your thing, and they concentrate it and make artificial stuff of it and put it. Very complex biotech thing. With the consent of the lawyers for each party, the House of Lords had 3 successive Tuesday mornings with a professor from, I think it was Oxford, wasn't it? Huh. Not the other place. Professor from Oxford, who taught them the background of the science. When you're a judge in trial, you usually don't have that luxury. You rely on the experts. What do you do beforehand? Some judges look at Wikipedia, although if you give them that in evidence, they're going to throw it at your face. A lot of us have law clerks now who have a lot of training already in that. I had last year a law clerk, a very clever Korean guy, who taught me a lot about molecules. And we were talking away, and he was doing things on a little handheld thing. And he said, here's a picture of the molecule. And there it was in 3D, rotating around and so on. You know about these things. So you have that resource. You try and get the experts to tell you. And you try through the hot tubbing if you're still perplexed about that. Now, some people are slow learners and some people are quick learners. I don't know if you've taken Justice Snyder's decisions in what she calls the Prill cases, Ramaprill and so on. She calls herself the Prill Queen now because she's had about 5 different Prill patents. And so she's pretty well known now from the patents that she's decided, cases that she's decided about this area of technology. But you have to, let's come to the bottom. You're law clerks, experts, a little bit of outside reading. You'd love for the lawyers to say, here's a textbook by Weber on molecular physics, a very readable textbook. Why don't you read that and we'll start from there, you know? Sometimes that's done, not often. Yeah. You got a mic?
Thank you very much for a very wonderful and educative lecture. My question pertains to the more or less overwhelming impact, so to speak, of drug cases on patent law in Canada. And it does sometimes concern me in terms of the language and how the judges frame some of the discourse, which seems to somehow become a little bit more difficult to transpose them or to translate those principles to non-drug cases. For example, if you look at Sanofi's Cicintelabo and the obvious to try test, supposing one we are faced with, let's say, an infringement case concerning a bicycle or a motorcycle, something like just a typical device, it becomes a little bit difficult to apply that kind of language in terms of a test. So my question is, what are the drawbacks, so to speak, of this overwhelming number of drug cases that arise in patent law? And if there are any drawbacks, really, how would you, as a judge, go about trying to kind of strike a balance in the phrasing of the words? Thank you.
I think you're asking, I guess, about social policy more than legal. I'll give you an anecdote. When I was a lawyer, I acted for the company that everybody paints as evil, Monsanto, for a genetically modified crops case in the Supreme Court of Canada. And as our legal team was walking up the steps of the Supreme Court of Canada, a bunch of people came out of nowhere looking like waving wheat. They dressed themselves as wheat. And they were waving and so on. It looked kind of interesting. I think it made the news that night. It's, the issues that you have to decide are not social policy issues. If you were asked if a patent's valid, you don't then go on to ask whether Viagra is a good idea, allowing old gentlemen to compete with the younger boys for the ladies. There's no social aspect of that going on in your head. So that rarely in intellectual property do you get social thing. That's for somebody else. So our decision is to decide the case in front of us. If somebody raises an issue that is properly within the jurisdiction of the court and deals with the subject matter at hand, of course we have to deal with it. But social issues as such, no. Have I answered your question?
Let me maybe rephrase. I'm just concerned about the dominance, so to speak, of drug law cases, patent law, and how the language often used to analyze the cases and to make decisions somehow make it difficult for one to apply those principles to non-drug law cases. You look at chemicals, for example, the doctrine of sound prediction. Who is going to apply that doctrine to let's say, a device like a camera if there was a dispute as to a patent relating to a device? Or you look at, let's say again, Sanofi's Cintalabo, where the Supreme Court was talking about the obvious to try a test. And it becomes difficult if one, let's say, as a judge, you are confronted with a patent infringement relating to any device or any machine. So my question is, how would you, as a judge, help us to somehow modulate the kind of rhetoric, and let me not say rhetoric, the language that is used, not necessarily, so to speak, with respect to drugs, but which may not be relevant to non-drug patent infringement.
I think I got it now. First of all, I would say about 90% of the cases that we have been doing in the last 10 years are drug cases. So there's no doubt that the language that drug cases evoke is the language that you hear. When you turn to, let's say, a piece of machinery patent case or something else like that, the language may or may not be pertinent. But we have in Canada sort of developed language that other countries find strange. If I said sound prediction, an American would not be very happy. If I said promise of the patent, most people would be puzzled. These are things that are almost uniquely Canadian and have evolved through our system. We have been criticized by others to that extent. We are evolving and developing our own body of case law that's a little different and a little strange from the rest of the world. It's because of the fact that it's developed through the drug patent system. and the drug patents, people tend to file patent applications for drugs rather too early in the development stage. So they try to say, well, when I was developing a drug, really I gave you everything that a smart person would need to know to arrive at Viagra. That was the case recently in the Supreme Court of Canada, and they said no. So there's no doubt about it, the language is influencing it. I don't hear that language in non-drug cases, and to some extent, we're strange. Is that a good answer or just the truth? Okay. Somebody else? Peter wants to close it off. Okay.
Great to meet you finally, Justice Hughes. I was wondering, even during your speech here, you seem to be speaking quite positively of the hot tubbing method of litigation, and I believe you actually did the first judgment on that in AstraZeneca. That was the first time it was used here. And I was wondering if you could maybe speak to, I mean, you seem to view it quite positively. What besides sort of general benefits, what do you think are the big benefits that in your opinion, of the process?
One of the problems that the courts have faced, and this is, in every, let me say, common law structured court system, as opposed to the Europeans, which are different, they treat experts differently, is the expert witness. And for a long time, there was a tendency of the experts to get what I call the Stockholm syndrome, that they very much get involved with and side with whatever party has retained them, and they go to lunch with and stay at the same hotel with and all of that. And you find that they become almost an advocate for their side. So that many jurisdictions, the UK has a case called the Icarian Reefer, which is the start of the process. Ontario then developed a set of rules. We've, in the federal court, have adopted a set of rules and gone towards the hot tubbing the Australians do too. That an expert has to read these set of rules that essentially say you're an expert for the court, not your client, not your party. That you will be neutral and independent, and you'll sign a document to that effect. I've heard anecdotally, since this was happened after I got on the bench, that it's had a salutary effect on several of these experts. Hot tubbing is another step on that route to sort of depoliticize or de-align the experts from the parties that have retained them, so that you know that if you're answering questions not from a lawyer rehearsed or cross-examination coming from left field at you, but from somebody who knows as much as you do, or about as much as you do about the same subject matter, you're talking to each other. That you're not going to try to snow each other or put a fast one by. We know the guy who believes in green men and flying saucers and which one doesn't. So that's another step along the way of sort of encouraging a professional integrity in the experts. I had a case recently where I didn't use it, where the expert, when one was being examined, the other, I threatened to use it. The threat was enough. Where the expert was examined and the other one was in the audience, and just having that other one in the audience was enough to keep the one in the stand. And then they switched, of course, places, and they pretty much arrived at sort of just that. So it's another way of keeping them on track. Yeah.
Thank you. I guess I'm one of those members of the public that are running around madly. I'm not from this faculty. I'm from the Faculty of Fine Arts and the Department of Design. And in the last few months, a lot of issues have come to the surface to do with copyright. And I'm just curious, it's something that is quite clear in graphic design practice, that you can give up your copyright to a client. You never give up your moral rights. I understand that. But what's starting to happen in the university, and I think it's not only at our university, but what's starting to happen is that we're being asked to develop collaborative courses where we have people from outside coming in. Knowledge mobilization starts to include members of the community. So and this has to do especially with undergrads, because with grad students, it's quite clear that their work is their own and
Okay.
that they own the copyright. But I'm getting concerned, I have a large concern here that in the classroom, how, as academics, do we protect our students and ourselves in a climate where there's an expectation for us to relinquish these copyrights in these sort of collaborative projects or collaborative situations?
Okay.
Just wondering if you have any thoughts on that, because we're trying to develop some kind of a guidance document for our faculty.
There recently has been several reforms to the Copyright Act. You're familiar with that. And Justice Rothstein, I don't know if you were here for that, but he spoke on several Supreme Court things. There is nothing that absorbs more time in academic circles and in the circles of people that want to change or reform statutes like the Copyright Act than that kind of debate. They debate endlessly about that. And we rarely see the cases in the court. You know, people say, well, what if you sue a grandmother who's, you know, I've never seen a grandmother sued. But the law, if you like, is established and developed at this level, at the level of the debate and at the level of the reform to things and articles by various people. They never come to court. They just sort of write articles to each other. And it's a policy decision that's hard to draw a line. The Copyright Act reforms have drawn certain lines for educators, but really you've got to sit down with your powers that be in here and elsewhere to decide where for you and for your faculty the line's going to be drawn. And that's a matter of negotiation. It's sort of like the hockey players in the NHL union. It's really not a matter for courts. Because for the court, it will say, well, here's a piece of thing that's been done by the professor. In the first instance, perhaps the professor owns it, but if the professor is under an explicit or even implied contract with the university, what does that contract say? And so on. And if the professor's work is nothing more than a collection of, you know, somebody else's article, somebody else's article, somebody else's article put together, well, yeah, there's copyright in a collation of material, but is it original enough to make it different? There's all those questions for which there is no one right answer. So the answer is, just like the hockey players, go out and negotiate or else move to Russia and try to make your money there.
I think that we're along the right track in trying to develop our own policy, and I think that's what we're going to try to do, but
Sure.
it's a big issue. Thank you.
Anybody else? Yes. Got to use one of these. I guess it's because it's being recorded.
Hi, my question is more on the philosophy of law. So I'm.
Is there such a thing?
So, especially with regards to copyright and the need for a fixation, for a work to be fixed. I'm just curious how, especially considering that doesn't always translate, for example, when it comes to collective authorship and indigenous cultures and that type of sharing of knowledge. So I'm wondering, with that in mind, what you think the role of judicial advocacy is.
Judicial advocacy. Well, we speak through our reasons, don't we? We don't go around saying, I think the law should be that professors get all the copyright and should make as much money as the dean. You know, we don't say that. I know that's of great interest and occupies all the time in the coffee room about who gets what with what. In the specific instances that we get, yeah, we'll decide it, but we get virtually none. It never gets to the court. It's because you have to resolve it among yourselves. It's just like, you know, mother of kids saying, why are you squabbling over there? Go and resolve. But he, oh yeah, but I was the first one. Yeah, you know, you're both right. Everybody has a rightness. And I'm not saying that anybody has a position that is morally indefensible or morally upright. The point is that it's something you got to work out. Yeah, you've got works. And what what I found when I was a lawyer is somebody would come in and say, they're suing me for, or they're threatening to sue me for infringement, and all I did was take 3 lines. The other person would come in and say, you know, I wrote that whole poem, and they took 3 lines of my best poem, and it's all down to nonsense because there's no money in it. You know, you get paid your salary. Now, how much more do you want? Do you want to be Bill Gates? You know, I do. Everybody else does. But it's really one that you're debating it in the right form, and you've got to resolve it in that form. Like adults. Okay. One more? Yeah, sure. You have to use the microphone.
You touched a little bit on this, but as a law student, almost finished and almost ready to go out there, I wondered if you had any advice on good learning opportunities or things that we should be doing before we go out there, in hopes of becoming, you know, a successful lawyer like you are, or a judge. Whether there was any specific advice you had for the new students coming out, particularly in the intellectual property field.
Wow. Well, it's a very wide open question, isn't it? First of all, I have personally a level of amazement that they're opening up new law schools and that current law schools are expanding their enrollment, because I don't know where the system's going to absorb all these new people coming into the market. There's only so much in the market. And so many of you want to work in downtown Toronto. Nobody thinks of Fort Francis or Kapuskasing as a place to work. They all want to be in, what do they call it, the Golden Triangle, or whatever the words are for that. Frankly, I think there's too many law students coming out now for the market that's there. Now, if you're coming out, then what are your expectations and aspirations? My wife is a lawyer, and she has come to Osgood from time to talk about, now that you're a lawyer, what jobs are there out there for which you are qualified as a lawyer, but aren't legal jobs, you know? Business administration, there's many other things too that are out there. So are you thinking about being somebody standing on their hind legs in front of the Supreme Court of Canada, earning a great deal of money, adulation, respect on the front page of the Globe? That happens to about 1% of 1% of 1% of 1% of the people. So let's talk real. Real is that it's a crowded field for which there are many candidates for almost any position. I would not like to be a law student today. When I was a law student, graduating, I got 5, 6, 7, 8 letters from all the downtown firms saying, come on and join us, and all of you can earn up to $6,000 a year with us, you know. They spill that. They spill that much over dinner, you know. So it's difficult. Is there something that will give you an advantage over somebody else? Probably knowing somebody, yeah. Being the son or daughter of the senior partner of a major law firm is probably a pretty decent advantage. If you're not that, then you're going to have to get out there and compete. Do I have one particular thing? I know what I look for law clerks. I don't know if any of you tried to do that. I have a law clerk, and every year I have a different person who is my law clerk, and they're generally somebody who is in lieu of articling will come and work with me, or some of them are graduate lawyers, depending on what system, but recently graduated lawyers. What do I look for? I look for somebody who has enthusiasm for the law, somebody for whom this is what they want to do, somebody who looks like, I'd like to be a lawyer, I'd like to be enthusiastic about what I do. I'm not, you know, it's interesting that you bicycled across the Gobi Desert. It's interesting that you got an A in this paper, never mind the C in that paper. But really what I'm looking for is enthusiasm. Somebody who really wants to do this, as opposed to earn money until lightning strikes or something. Yeah. Not a good answer, is it? I haven't given you the secret. There is no secret, as I say, except being the son or daughter of the senior partner. What they call the lucky sperm club. Okay, that it?
Anyone else?
Okay, come on, Tina. Yeah, you want to close it off.
So, well, it's time to say thank you to you.
Okay.
So this is something from us on behalf of IP Osgood.
Thank you.
Thank you.